How are you doing?
I am fine. Question.
Shoot.
All right. A friend of mine was at an event, and he went to walk along the pavement to actually shoot that the pavement was wet. But when he took a step onto this pavement, it was a kind of a marble, but it was rain. He slipped, and next thing he knew, he was out for a second. His head was hurting. The world was black, and then someone tried to talk to him, and he said, "Help me up." And it turns out there were these security guards that helped him up, who were at the shopping center where it happened, and he then went to cover the press conference there, but decided, hey, I can't admit there's something wrong with me. I'll put some ice on, and he had some few headaches, but he still has occasional headaches. Over the past 6 months. What kind of civil legal remedies are available to him?
Okay, first of all, although it sounds like a fairly simple case, it's not. It's very complicated. The standard civil, we're talking California law, where this happened, I assume, so under California law, there's generally a 2-year statute of limitations to cover you, except for the fact that you talk about it was on pavement of some kind, which very easily could be publicly owned, as in
this case it was.
City of San Leandro,
Just as an
Los
example.
Angeles,
or
wherever,
yeah.
is a 6-month claim statute that you got to file a claim with and comply with that in order to perfect your right. There are some exceptions to filing for a late claim later on in a petition.
What exceptions are those?
They're very limited. They're reasons that you have to come up with a very good excuse for not filing the claim in time. If someone was unconscious for
So my friend has one more month, it sounds like.
If that's when it happened, almost 6 months ago, 1 more month. The only exceptions would be to unconsciousness or inability or a minor or something like that. Otherwise, courts are, first of all, the entity very rarely grants an application for leave to file a late claim if you're late. You then have to file a petition with the court that starts off with $475 or whatever it is, and the courts don't ordinarily grant those petitions unless good cause is shown. So with the being unconscious or in a hospital, something like that might work, or a child automatically will work. With those exceptions, limited exceptions, that's it. You've got to comply with the 6 months. So you tell your friend he'd better file a claim within the 6 months.
Does that cost money?
No, claim itself probably costs nothing. You get a form off the internet or the city office or whatever, wherever it happened, and fill it out and serve it on them within the 6 months, and that'll perfect your right to pursue the case. Thereafter, you wait 45 days for them to act on it. If it's not rejected, it's deemed rejected by operation of law after 45 days, and you can then go ahead and file a lawsuit. As an aside, if you never reject it, it just sits there, you have up to 2 years from the date of the injury to file a lawsuit.
But you have to file the claim first.
Claim has to be on file.
Now, what is it to
properly.
file a claim? What does that mean?
It means you put them on notice that you're making a claim against the entity for damages, where you put in the amount of damages that you feel that you incurred or possibly will incur in the future, and basic description of how the accident occurred and why it's their fault. Now, jumping back a little bit, you said that was probably public property, and public property means owned by the city. But there are instances where it is private property adjacent to the city that you don't realize is private property.
Okay.
And if a
Well, let's pick up on, if I may, because the person hit his head on a girder that supported a bleacher system that was operated by the event producer, which is not the city of Los Angeles.
You're right. And that's absolutely, if the event producer is a private individual, that is a 2-year statute, and you might have a claim, or that person might have a claim for having a girder put out in an area where things are slippery. Now, you mentioned marble. I don't know if it's marble or not. You see very little marble on the streets anymore. They've got terrazzo and marble and these things, and they are notoriously slippery.
When wet.
When wet. And so that type of thing is, you may be able to file a claim and a lawsuit and pursue it through a basis that it is notoriously slippery. However, it gets a little tighter because you have to prove normally that they created the dangerous condition, or they knew about it a sufficient period of time prior to the accident to have taken preventative measures to protect you.
Can you?
Either one of those is a failure of. Go ahead.
I have to ask: can a person claim that by the existence of the material and the contact of the water, that this was sort of a ticking time bomb? That even if my friend can't find a person who went through a similar incident for whatever reason, the simple fact of the matter that this condition exists, this environment exists, like environmental impact reports, is bad enough.
Okay, on that, the proper way of doing it obviously is to have an attorney representing you, but.
You sure? Like you.
That's right. Dot the i's and cross the t's, but is to get an engineer to do a coefficient of friction test. So they can go down and replicate the wetness, do a coefficient of friction test, and if it is below the required coefficient of friction, they're expert witnesses that it was dangerous and defective. And you're entitled to an award on that basis. That's not to say the other side won't have somebody there excusing them for it, so it's not a guarantee, but that's the one way. A second way, and it's difficult to do, is we put out on our listservs, it's trial attorney listservs, where the accident happened, and to find out if there had been previous slip and falls there before. So if there's any history of other people slipping and reporting it to them as dangerous, then they're on the hook without an expert.
And given that this is a shopping center, there's got to be something out there, right?
Yes. So the question is, can you pick that up the internet or during standard searches or through a trial lawyer listserv, or do you have to actually go into the litigation
and pull them out?
Then you do it by request for production of documents.
Would you use LexisNexis, for example?
Not really. That's for law,
Uh-huh.
more so. That's not for identifying prior claims. Prior claims, you'd find, simple thing is, which city of Los Angeles, it's not simple, but as you can check out claims filed or lawsuits filed against the city that have that location. Then you could find out whether someone else might have had a claim.
Interesting.
So-
How common, let me ask this another way.
Sure.
Are slip and falls the most common type of personal injury claim?
Probably not. There are a lot of them, but very few of them are successful. Because you still, for the most part, have to establish notice. And the defendant on the other
Again,
side...
to establish notice is to file on time,
No.
Oh.
You have to prove that they knew or should have known that there was a dangerous condition. And basically, on slip and falls, where there's a foreign substance or something else, the answer is we had no claims before. We didn't know anything was dangerous until you fell. And that kind of absolves them unless you have an expert witness who says, given the wetness, that was dangerous and they created it and they should have known that. So that's that aspect.
Yeah.
The other aspect is obviously on the injuries and evaluating the case, whether you want to proceed with it or not. You have to evaluate it on the basis of how much is it ultimately going to be worth. So if the ultimate worth is not significant, then it usually is not economically feasible to handle because you're wasting, the injured party's wasting their time and so is the attorney.
how do you determine what is a significant amount?
I think a rule of thumb is minimally $50,000 or more value. So the attorney has to assess, if we get into litigation, how much is that ultimately going to settle for? Or if I go to trial on it, how much am I ultimately going to get? That's usually more than what you settle for because you also have to evaluate the chance that you could lose the case. So, but if you're getting much below that, then how do you afford a $5,000 or $10,000 expert witness to
Right.
go out and evaluate it and testify? Number two, when you get your chance to go to trial, medically you're not able to effectively testify as to your injuries on your own. You need a medical doctor who can testify as to objective signs of injury and can either a post-traumatic stress syndrome or a post-concussional syndrome or something like that. They need to be able to testify and to a jury or convince somebody that there is an injury, because
Yeah.
jurors are sort of skeptics. And if they don't see an x-ray showing something broken, or a CT scan or something showing a hematoma on the brain or something like that, they tend to get conservative. So that's part of the evaluation.
Now, how do people contact you?
Either by email or by call. The office number is 510-839-7722. And the email is basically Robert Schock, SCHOCK, at legalpros, LEGALPROS.com. Excuse me, .org.
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 Okay.
Forget my own one,
Okay.
but that would be the two ways.
And we'll be back to ask you more questions.
Okay, thank you.
Okay.